Immigrant Survival Show for millions of immigrants. America is not just a country. It is a dream of freedom, opportunity, and a better life. But behind the dream lies a system filled with confusion, fear, and life-changing consequences. One mistake can destroy everything, but the right knowledge can change everything, helping immigrants achieve the American dream without the nightmares. If you are an immigrant in America or you are abroad trying to come to America, you cannot afford to miss this show. Learn how to avoid mistakes that can destroy your case. Discover hidden pathways to adjust and protect your status. Stay ahead of immigration law change and how to prevent your American dream from becoming an American nightmare. Starting now. The Immigrant Survival Show. This is where knowledge becomes power. Welcome to another exciting edition of the Immigrant Survival Show with Ope Banwo and his team of Samuel Ope and Grace Okafor, as we bring to you tonight another one of our shows where we discuss immigrant matters. And today is day 30 of our 30 days marathon Immigrant Survival Show as part of our introducing our new law firm in Dallas, Texas. And of course, after today, we're going to go to once a week, and our weekly show, I think, will be on Mondays. And then you get to see us for 2 hours every week. So welcome. As usual, the first thing we're going to do today is to first appreciate my team, Grace Okafor. Thank you for what you do. And also Mr. Samuel Ope. Thank you so much for helping with the research and for getting everything ready to make sure I do my part. Thank you, guys. As usual, please stay in the studio to help me bring up the questions, to help me attend to the audience who might need assistance. So I'm going to put you in the studio as usual. All right, guys, welcome. Today, as always, we are going to start with my memo of the day, which I try to use to educate us a little bit better on some fundamental issues to do with American immigration. We don't just want the show to just be about Q&A. Then after the memo of the day, of course, we're going to talk about the latest updates that is making the rounds, the biggest of which, of course, the defeat for Donald Trump at the Supreme Court about the automatic birth rights for people born in the U.S. We're going to talk about that, as well as 3 other powerful updates that will affect your American dream for those of us who are living in America already, and for those of us who are dreaming of coming to America. So stay tuned for that. Then after the updates, of course, I'm going to take your questions as you post them in the chat with the assistance of my team. They're going to bring your questions in, and we're going to try our best to provide answers, not just for you, but that can also help as many people as possible who may be listening to this show today. So once again, welcome to the Immigrant Survival Show with Ope Banwo. But it might be with me, but I'm not alone in this game. I've got a great team behind me, those you see and even those you don't see. So let's go to the memo of the day. The small immigration mistakes that are destroying people's big immigration dreams in 2026. I like to talk about visionary issues and matters that affect almost everybody that live in America right now, or America that want to, those who want to come to America, in this opening section of my show, the memo of the day. I call it the Rottweiler's memo of the day. Today we're going to talk about the small immigration mistakes that are destroying big immigration dreams in 2026. So good evening, Rottweilers, as I like to call my viewers. Today I want to tell you something that may surprise you. When most immigrants think about losing the American dream, they imagine something very dramatic happening. An ICE raid, or maybe a deportation order, or maybe a visa denial, or an immigration judge saying application denied, like it happened many times for many people in court today when I went to court and several people came without lawyers. Several of them were deported. They think something dramatic like that is what will end their dream. But after nearly 3 decades, almost 30 years, practicing immigration law in America, let me tell you a painful truth. Most immigration dreams don't die because of one big catastrophe. They die because of one small mistake, a tiny mistake, a forgotten document, a deadline that you thought could not wait till tomorrow, or could wait till tomorrow. Forgot. Let us go live on Instagram. I almost forgot that. Let's do that. Okay, I think we are live on Instagram too now. See, I'm back to the memo of the day. A lot of people think of a lot of dramatic stuff when they think about their dreams possibly dying. Yet, most times, it's something very small. I know this after many years of doing this. A deadline that you thought could wait till tomorrow. I remember I was in court yesterday. The judge said, file this and file that before the 7th of July. And I didn't write it down well. I thought he was talking about August. Thank God I asked him just before he adjourned the case. I could have ruined the dream of my client. Deadlines, you missed it, the judge orders your client deported. There's no story. It could be a letter from the USCIS that you didn't open because you were afraid of what it might say. It will surprise you how many people get a letter from immigration and they don't open it. Or it could be a change of address that you never reported because you thought it's just a few months. But the law is that you have to report your change of address immediately it happened, because they're going to be sending letters to the address that they have. It could be one missing signature, one wrong date, one wrong answer on a form. It could be one court hearing that you missed because you confused the date, like I almost did yesterday. It could be one request for evidence that you ignored because somebody on Facebook told you, oh, don't worry, they're just buying time before they rule on your premium processing, so don't worry about it. It could be one immigration form that was prepared for you by your cousin who claims that he knows, quote and unquote, immigration law. It could be one piece of legal advice that you got on TikTok. And because the man looked very serious, because the man talked persuasively, you thought he was correct and you acted on it. It could be sending your application to the wrong address. This also almost affected me recently because immigration changes these addresses all the time. And I mailed out an application using the address that I used 3 months ago, not knowing that they had changed the address you mail those kind of applications to. I didn't make my last minute check as I always do. And that application hung there for about 3 weeks. Then we started wondering, how come I don't get a receipt notice? By the time I checked, I realized that the address I mailed to had changed 3 weeks ago. And we had to resend the whole thing. Thank God I found out on time. Imagine if I had been waiting without I normally would do a status check every time I mailed something. Just waiting for them to give a decision. I could be there for 6 months or 9 months before realizing that my client's dream just got shattered because of one small mistake by me. It happens all the time. Small mistakes is how most dreams end in America. All it takes is one, just one. And suddenly, years of sacrifice begin to unravel right before your eyes. I've seen brilliant engineers lose their green cards because they missed an RFE deadline. I've seen international students fall out of status because nobody explained the rules to them properly. I had some in my office, at least one of them in my office a couple of months ago. Nobody explained to him that as an F1 student, he had to carry full load. You can't just pick 1 or 2 subjects and do it. Nobody explained to him, and he thought it was good. For 3 years, he was picking the few courses he would do until he got a letter from immigration that he has been out of status. Small mistakes, small carelessness. I have seen asylum applicants lose perfectly good cases simply because they failed to notify immigration after moving to a new apartment. And then letters were sent to the old address, and they never got it. Because immigration letters will not be forwarded. They don't forward their letters. Post office does not forward it. They're going to take it right back if it's not deliverable. I've seen people become subject of deportation, not because they committed crimes, but because they ignored paperwork. I've seen people lose a perfectly good case because they thought they could do it themselves. And then they fill out the form, and some of the questions in those forms, they are counterintuitive. So they answered yes instead of answering no. And then, before they knew it, they have been accused of lying to immigration. Now they are talking about visa fraud for them, and they're like, what are they talking about? I'm like, yeah, that's what they are talking about. Because when you're filling these forms, you assume you know the answer. And sometimes the answer you think is not the answer you're supposed to give. That is the tragedy of immigration law. Immigration law is in America, it's one of the few areas where tiny mistakes can produce life-changing consequences. And in 2026, under this particular Trump administration, those small mistakes matter even more than ever. Immigration is scrutinizing applications more carefully. ICE is enforcing compliance more aggressively. Immigration judges are demanding greater accuracy. Deadlines are being taken more seriously than ever. This is no longer the immigration system where people can casually fix mistakes a few months later. Today, compliance is king in America. Accuracy is king. Documentation is king. Preparation is king. It is, I've seen that in practice so much that before I mail anything out now, I have to double check it at least 4 times. When I'm done, I double check. I give to my paralegal to look at. After they've double checked that everything is arranged well, I leave it on my table till the next day. When I come back, I look at it again. Sometimes my staff think that maybe I'm just being pedantic. The way I keep telling them, have you reviewed it the second time? Have you reviewed it the third time? It's because I understand this. It's not about whether you gave wrong legal argument that make you lose cases. Small mistakes, like wrong address, like wrong yes or no. Those are the things that trip up most people these days. Preparation, therefore, is king today, not so much your intelligence, your compilation, your documentation. And that's why I always tell people something they should never forget. Your biggest immigration enemy is usually not ICE. It is not USCIS. It is ignorance. The immigrants who eventually succeed are not always the ones with the strongest legal cases. Very often, they are simply the ones who stay more informed. Those who keep copies of every document. Those who open every immigration letter that arrives on their door. Those who respond immediately. Those who ask qualified professionals instead of WhatsApp University or Facebook professors. Because everybody thinks they can Google now, they can chat GPT now, and they have answers. But sometimes the practice on the street is different from what you are Googling. Those who win are those who understand that immigration is not something you wink the way we used to do it. Lots of people can win this thing and get away with it. But today, it is something you manage strategically. So today, before we get into today's updates, let me challenge every immigrant watching this broadcast now, and I don't care if you already have you have your citizenship, because you're finding out now that you can lose that citizenship too. Because now, little mistake like just talking very negative against America on your Facebook page can get you into trouble on your way back into America. It's happening. And before you know it, they are saying they want to take away your citizenship. It will be you like dream. So before we are even going to today's updates, I'm going to challenge you Every immigrant watching this, either intending or those who are here already, ask yourself these questions. Is immigration using my correct address? Have I opened every immigration letter I have received, even if I thought I knew what was inside? Do I know my next deadline? If you have a case with immigration, do you know when your I-94 expires? For those of you who are visiting our country, I've seen that trip. So many people now, even including professors, because many assume that the date on their multiple entry visa is when their status expires, and that's not correct. Your status expires with the day they give you on the I-94. Meanwhile, when you come to America now, they don't give you I-94 at the point of entrance anymore. Before, they used to give you this white card. They staple it on your card, on your passport, so you know you can be looking at it every other day to know when your stay is going to expire. They don't tell you anything. They just say, welcome to America. You have to go to their website, the CBP website, to go print out your I-94 so that you can see how many days you are given. In one of my broadcasts a few days ago, I told you about my friend who almost entered the immigration problem because she had assumed that they were going to give her 6 months. But they gave her 30 days without even telling her. And she was planning to stay about 2-3 months because she had some emergencies to attend to. Until something say, go check your I-94. And then she checked it. She realized that she was given 30 days. A small mistake like that could create a nightmare. Whether you have 10-year multiple entry will not matter. If you stay beyond that day and you go outside the country when you're coming back, then you're going to know how costly a small mistake like that is. You have to ask yourself, what is my next deadline? Ask yourself, am I relying on legal advice from licensed professionals or from strangers on social media? If immigration contacted you tomorrow, would you know exactly what to do? If immigration showed up at your door right now, do you know what to do, especially if your papers are not very current? Those are things you need to ask yourself before you take another day in this country. Because sometimes the difference between a green card and a deportation order is one overlooked envelope. Don't let a small mistake take your dream from you. Stay informed, stay compliant, stay prepared, and above all, protect your American dream like your life depends on it. Because sometimes it actually does. Everybody will tell you they hate America. America is no longer a great country. I hate America. Yet, nobody wants to leave. Not the ones that are here. Be careful. Stay informed. Know what your next move is. If you're in this country, and especially for those of us whose papers are not yet complete, get professionals. There are immigration lawyers everywhere. I'm not simply saying go to speakwithope.com and book an appointment with me. That would be nice, but it's beside the point. There are lawyers in your town. There are lawyers you can Google at a point of Google to find lawyers that can help you. Do that. If you have to pay them consultation just to get rest of mind to know your exact scenario, please do it. Pay them. Most lawyers will charge you $100, $200, maybe the most expensive consultation out there, maybe $300. Pay them. Know where you stand. Because one small mistake can torpedo years of planning, years of hope for you. And that is my memo for today. It's tough out there. Have knowledge. I'll give you a story that happened yesterday in court. Before, until they changed the rules recently, without some lawyers knowing, if you have a client who, for instance, is married to a U.S. citizen and is in deportation proceedings, all you simply tell the judge is, I want you to help me postpone the case. Continue the case is what we call it, but let me use street language. Postpone the case so that immigration can decide on the application that my husband or my wife has filed for me. But they've changed the memo now. They've changed the operation now. Now immigration judges are no longer waiting for you to go and get a decision. They will not postpone the case for you. And if you don't have a relief to ask for, when you go to court that day, they're going to order you deported right there. I saw it happen yesterday. It's all part of what I'm saying. Know what your next move is. Because this particular immigration system may just surprise you. That is my memo of the day. And when we come back, we are going to get to the updates. And there's some doozy ones that have happened today. Of course, everybody is talking about the biggest one, the ruling of the Supreme Court on birthright for illegal aliens in America. It's been one of the most awaited decisions of the Supreme Court for a very long time. And it came down today, thank God, the immigrants are jubilating over it. And we're going to talk about that. Is it really time to jubilate? Is this, what do you do now on some of this stuff? But when we come back, we'll talk about all of that. But first, I want to show you, I want to debut one of the short videos that we sponsored in my law firm and that is made in collaboration with ISEN. We have this thing that we are doing where, as part of us recognizing the contributions of immigrants to America, we sponsored a series of documentaries to celebrate some of the greatest immigrants who have ever come to America. Just to let everybody know, immigrants didn't just come to take. Immigrants were co-builders of the American dream. And sometimes we forget this. But this series is a series of, I think, about 14 episodes of the Immigrants Wall of Fame. We celebrate some of the best immigrants that have ever come to America to help build the American dream. Today, we're going to be debuting Albert Einstein. Many people don't even remember that Einstein was an immigrant, and yet is one of the biggest, most remembered faces and names all over the world for his contribution to American science. Enjoy. When we come back, we will talk about the updates for today.
Banwo Law and Eisen proudly present the USA Immigrant Hall of Fame, celebrating remarkable immigrants who came to America, overcame adversity, achieved greatness, and helped shape the greatest nation on earth. Their journey, their sacrifice, their legacy. Before he became one of the greatest scientific minds in human history, he was simply a frightened immigrant, a refugee, a hunted Jewish intellectual fleeing terror. The man whose face would later symbolize genius itself once arrived in America carrying fear, uncertainty, and a foreign accent. Imagine that for a moment. One of the greatest minds ever born almost became another victim of hatred. But America opened its doors, and the world changed forever. Albert Einstein was already famous in Europe. His revolutionary ideas about space, time, energy, and gravity had stunned the scientific world. But brilliance could not protect him from hatred. Adolf Hitler and the Nazi regime began targeting Jews across Germany. Jewish professors were fired, Jewish businesses destroyed, Jewish families hunted, and intellectuals like Einstein became enemies of the state. His name appeared on assassination lists. His books were publicly burned. His life was no longer safe. So Einstein made one of the hardest decisions any immigrant ever makes. He left home, left familiarity, left his country, left the world he knew behind, hoping another nation would give him a chance to survive. When Einstein arrived in America, he was not the legend yet. He was an immigrant trying to rebuild his life. A foreigner with an accent, a man starting over in unfamiliar surroundings. Imagine the loneliness, the uncertainty, the emotional exhaustion of knowing you may never truly return home again. But America gave him refuge. America gave him safety. America gave him the freedom to think, to teach, to dream again. And in return, this immigrant helped reshape modern civilization itself. Einstein's theory of relativity completely transformed humanity's understanding of the universe. His discoveries became foundational to modern physics, modern technology, modern space exploration, even systems we use every single day: GPS technology, satellites, nuclear science, advanced engineering. Much of modern civilization rests on breakthroughs connected to Einstein's work. America didn't just save a refugee. America unlocked a gift to humanity. Think about that. A frightened immigrant fleeing persecution became one of the greatest contributors to science in human history. And America became stronger because it chose compassion over fear. Every immigrant carries a story the world cannot yet see. Some arrive with nothing except hope. Some arrive afraid, unwanted, misunderstood. But hidden inside many immigrants are ideas, talents, courage, and dreams powerful enough to change nations. Albert Einstein reminds us that immigrants do not weaken America. They help build it. They expand it. They enrich it. They help push humanity forward. Somewhere tonight, another frightened immigrant child is arriving in America. Another future scientist. Another inventor. Another dreamer. And history may one day remember them the same way it remembers Einstein. This tribute to immigrant greatness is brought to you by the American Immigrant Support and Empowerment Network, AISEN, and sponsored by Banwo Law and Associates, helping immigrants achieve the American dream without the nightmares.
Alrighty, hope you all enjoyed that tribute to Albert Einstein, one of the greatest immigrants that ever lived, that helped build the American dream that all of us are fighting to achieve. Now, let's go to the next section of this show, which is the updates from immigration in America today. Of course, the biggest one is what we're going to start with tonight, where the Supreme Court, by a vote of 6-3, gave a landmark decision and ruled that children born in the U.S. are U.S. citizens at birth, even if their parents were undocumented or lawfully present on a temporary basis. The court held that the citizenship clause of the 14th Amendment protects these children, and it struck down the executive order that sought to deny them citizenship. You know, when Trump came in, that's one of the things he tried to do, to remove the automatic citizenship for children who are born here by undocumented immigrants. And of course, like with everything, lots of lawsuits were filed. It made their way all the way to Supreme Court. And in one of the most awaited decisions of the Supreme Court, at least for immigrants in my time, it came out, and this time immigrants were left laughing last. So why does this matter to immigrants? Of course, it means, number one, your US-born child remains a US citizen regardless of your own status. They're entitled to U.S. citizenship at birth, whether you are documented or not. Number two, why it matters. It shows that constitutional protections remain strong for immigrants. Though I would like to point out that on this issue, I was surprised that it was a 5-4 majority that agreed that the birthright citizenship is protected by the Constitution. Yeah, I know the vote was 6-3 in the end, but the sixth person did actually not support the decision based on Constitution. He used a different way to arrive at the same conclusion that children born to illegal aliens are entitled to citizenship. So it was really a 5-4, which tells me that could have gone either way. Imagine if one of those 5 had gone to the other side. Then constitutional protection would have been removed. Nevertheless, the ruling reinforces that a president cannot change constitutional birthright through executive order. They told him he has to go back to Congress if that's what he wants to do, that any attempt to change this long-standing constitutional provision or protection will require a different legal process. He has to go back to Congress, let them go pass it if they dared. So that's an important thing that matters to all of us who are immigrants. Number 3 thing in there that matters to you and me as immigrant is that it provides certainty to thousands of families who have been uncertain for over a year now with when all this started. This decision protects countless immigrants, their families, from the uncertainty about their children's citizenship status. Those who are pregnant, who are planning to have children right now, those who don't have papers but who are having children, now they can breed, knowing that their children will get access to the rights and protection that come with being a U.S. citizen. That's why it matters to you and me. But here is my own Rottweiler's advice as Immigration Rottweiler on this issue. Now, though this ruling is encouraging, please do not assume that it solves every immigration issue for you. Birthright citizenship does not automatically give parents legal immigration status, and it does not protect them from deportation. So we need to calm down a little bit. Continue to maintain your lawful status wherever possible and explore all available immigration options to you. Don't wait, because these rules change every day. If you're entitled to something today, you don't tell yourself, I don't have money to do it yet, or I'll do it tomorrow, because by tomorrow it may change and you no longer get that opportunity. If your case involves asylum, adjustment of status, waivers, family protections, or removal proceedings, you want to seek legal advice before making any major decisions. Don't just decide on your own. Talk to a qualified attorney, immigration lawyer, not just any attorney, an immigration attorney. Let them break down your options for you, and then you can make a decision. Avoid relying on social media rumors. That is what is killing a lot of the people out there. Immigration law changes frequently, and every case is different. That's why you want to keep looking for a competent, current immigration attorney to analyze your case before you do anything. Even if you ultimately are going to file it yourself, it doesn't hurt to talk to professionals, spend that little consultation money, get clarity. Even if you don't want to pay for full service, then you can go do what they tell you to do. Bottom line of this update, this particular one, this decision protects constitutional rights of children who are born in the U.S. But parents continue working towards their own lawful immigration status through the appropriate channels. So it's a good day. It's a good day for immigrants. We rarely win things now in the current climate that we have. Most times it's a loss for immigrants. So we celebrate this one, and we thank those who took this all the way to the Supreme Court for their labor of love on behalf of all immigrants. Yeah, something to smile about now. All right, let's go to update number 2 for today. Because every day something new happens in immigration. The update number 2 today is that there's a Trump executive order that strengthens some EB2 NIW cases. I like to look for some of those good, positive stuff that affect us rather than all just wallowing in the negative news. Trump, a lot of people may not be aware, but Trump just signed an executive order that will actually help some of us who are contemplating filing EB2, especially the national interest waiver cases. So what exactly is this update? President Trump signed a new executive order today making artificial intelligence and AI-driven cybersecurity a national priority for the US. President Trump is saying AI and AI-driven cybersecurity is a national security priority for the US. And the executive order, directs federal agencies to strengthen cybersecurity. It creates new AI security coordination efforts. It protects critical infrastructure, and it encourages collaboration with private AI companies to defend America against AI-powered cyber threats. So you might be asking, what does this got to do with immigration? See, the way I think about this is very different. With this, why this executive order does not create a new visa category or automatically approve EB2 petitions, it officially recognizes AI and cybersecurity as matters of national importance. If you can read between the lines, that makes it another important piece of evidence for qualified professionals who are seeking EB2 national interest waiver visas. Why does this matter? If you are familiar with the employment-based visa categories, you will understand. One of the biggest hurdles in an EB2 NIW case is proving that your proposed work has substantial and national importance under the framework of what they call the matter of Danessa. I handle a lot of this. This is one of my areas of specialty, so I understand what this means. You have to establish that your case or your proposed work in the US has substantial merit and is of national importance. Now, and listen closely for those of you in the employment-based category who are eyeing doing EB2. This executive order now gives AI engineers, cybersecurity experts, if you're in that field, machine learning specialists, AI researchers, and other professionals in related fields a stronger government policy statement showing that their work directly advances U.S. national priorities. Because a lot of EB2 that get RFE, what they always mention there is that your work, you have not been able to prove that your work has national importance. But with a statement, an executive order coming from the big dog himself, now you can tie in that. Of course, the executive order is not a magic bullet. Immigration will still expect strong evidence showing your own achievements, your expertise in the field, and how your work benefits the U.S. beyond a single employer. But this is a big open door that Donald Trump just opened without meaning to for EB2 national interest waiver applicants. So here's my own strategic recommendation based on this update. If you work in AI, cybersecurity, machine learning, cloud computing, data protection, or critical infrastructure, or AI governance, ITs generally, this may be one of the best times to prepare and file your EB2 NIW petition. Don't wait, this might be the time to quickly put it in, because the most difficult part to establish, Donald Trump just opened that door with this executive order. So when you file, you don't just tell immigration that you work in AI. Instead, build your case around how your specific work advances America's newly declared national security priorities from the mouth of Donald Trump. AI is now a national security priority. So if your skill set, if what you are finding is in that area, now you have a big blue mark. Your petition, of course, should clearly connect your research, your publications, your patents, your software, whatever, your professional experience to protecting critical infrastructure, to improving cybersecurity, or supporting America's technological leadership. Because Mr. President has put it on paper now as an executive order that is a national interest for Americans. Remember, government policy opens the door, but your own evidence is what is going to get you through it. So you want to get competent lawyers to help you do proper documentation to tie it all in properly for you. And this may be a good one for you. I think that this executive order is another reminder that successful EB2 cases are won by aligning your individual accomplishments with America's evolving national interest. The national interest changes all the time. For qualified AI and cybersecurity professionals, that alignment just became significantly easier to demonstrate by your lawyer, assuming that he knows what he's doing, or you yourself, assuming, of course, you know what you are doing. I see that as a positive, another positive development for immigration this week. Me, I'm an optimist. I'm always looking for those loopholes that can get as many of my clients their papers as possible. And I hope you are hearing me. You're hearing me very clearly for those of you out there. The third update for today, and this one is not so good news. At least we've got a couple of good news. So you're not going to say I'm a prophet of doom. But this one, you want to pay attention to very well, especially for our F1 students or J1 students, the exchange visitors. Pay attention. This is an important update that just happened in the last 48 hours for you. DHS, that is, I like to call them immigration, because when you use all these abbreviations, a lot of lay people get confused. But the Department of Homeland Security have signaled that they want to end duration of status for international students. You know, as a student, when you come into the country, or as a J1 person, they give you your I-94 with a DS on it, duration of status, meaning that for as long as you're a student, for as long as you're in that status, a J1, then you are in status. But this is about to change, make a major change. Immigration is proposing, now I'm putting the word proposing, they put the proposed rule out there. They have not yet passed it. I don't carry rumors here. This is what they have proposed in their public statement. They want to make a major change to how F1 international students and J1 exchange students, how they maintain lawful status in the US. So pay attention here. Instead of the current duration of status, DS, which is what they put, instead of that system, which allows students to remain in the US for as long as they continue complying with the academic program. That's why you see a lot of students in F1 or J1, they just keep changing, they just keep moving from school to school. They finish one program, they want to start another one just because they have a DS. It's a strategy where some people become perpetual students for as long as they're going to school and carrying full weight. Your F1 remains valid. But now what they are saying is that most students will now be admitted for a fixed period of up to 4 years, or the length of the academic program, whichever one is shorter. So if the academic program that you got to F1, for those of us who go to community schools and all that, where your program is like 2 years and all that, that is what you are getting. They're going to give you a fixed period, not DS. That is massive. Meaning that anyone needing more time to complete a degree, maybe you had carryovers, or maybe you deliberately pick the long course because you want to stay here longer while trying to figure out how to get your green card. If you need more time, you want to pursue operational practical training or conduct doctoral research or advance to another academic level, you will have to file an extension of stay application with immigration. And many times that's where they get you. Now, this is important. I want to restate. This is only a proposed rule. Nothing has changed yet. So the current DS system is still in effect until they change it. So don't carry rumor and say they've changed it. that you had it from Dr. Ope, you had it from the Immigration Rottweiler. I did not say that. I said they have proposed. Normally, before they implement a rule, they propose it, they ask for opinions, they ask for comments. Eventually, they decide if they're going to do it or not. That's the stage they still are. Why does this matter? If finalized, this will be one of the biggest changes to student immigration in decades. It will mean, instead of schools largely managing a student status through the service, service is how they used to manage the F1 now, immigration will play a much larger role by deciding extension requests. That means more government oversight. That means additional fees that you're going to pay. That means more paperwork. And that means potentially longer processing times. Students in PhD programs, medical training, research, and other programs that often exceed 4 years could face additional uncertainty if extension requests are delayed, just like it's happening with work permits now. Employers who hire international graduates, especially in the STEM fields, could also experience disruption if employees are unable to obtain their extension. So this is a serious matter that is coming. And here is my own strategic recommendation for dealing with it. If you're an F1 student, J1 exchange visitor, or planning to study in the US, don't panic, but start planning. For now, nothing has changed. I keep repeating, continue following the current rules and maintaining your status. However, if this proposal becomes law, maintaining legal status will become much more dependent on careful immigration planning and timely filings. So you should keep excellent record if you're a student, avoid status violation, and begin preparing in advance for any program that may extend beyond 4 years. My advice has always been simple. Never manage your immigration status by deadlines. Manage it by strategy. The immigrants who stay ahead of the rules are usually the ones who avoid unnecessary immigration problems later. You're already hearing that they may do this to you if you're a student right now, a J1 student, whatever. Now is the time to begin to look for alternative solutions before you need it. Don't wait until it gets in there and then you start crying, start running around because it will be more expensive at that time. At that time, we may have limited options. So talk to lawyers right now if you're in student status, J1, and those status that may be affected. When this rule becomes final, and start talking to them, what can I do? What are my options right now? And start setting yourself up for those options before you need them. That would be my own strategic advice to you, because a word that is pre-announced is not supposed to catch a cripple unawares. A cripple that is wise will start running the minute you hear the announcement that war is coming. Same way here. This is the time to begin to think about your plan B, your plan C, just in case. And for many of this stuff, it always becomes law under the Trump administration. Once they say it, they're going to do it. So hope is not a strategy. Even though prayer is good, but planning is better. All right, update number 4 here. This is also good news. I like to talk good news on my show. There's not bad news for us as immigrants. This one is great news. Yes, a federal court in Rhode Island has struck down the USCIS pause, the immigration pause on immigration cases from 39 different countries. This is massive. In case you don't get it, let me explain to you what this update is. A federal court in Rhode Island ruled a couple of days ago that immigration acted unlawfully when it paused the processing of immigration applications filed by nationals of 39 countries that were subject to expanded travel restrictions. For those who have been affected, they know exactly what I'm talking about. When those countries were announced, immigration basically paused the application. Some of them have application for green card pending. Some of them have application for work permits pending. Immigration literally just paused. And some of them has been paused for months now. including those who apply for work permit. The court threw out 4 USCIS policies that had frozen or delayed many immigration benefits, including the processing of adjustment of status, green card processing, employment authorization documents, naturalization. A lot of people are qualified for naturalization. Some of them had even received letters to appear for ceremonies. The ceremonies were cancelled because their naturalization was paused because because Donald Trump had restricted travel from those countries. Even some certain asylum-related applications were paused. So now this judge in Rhode Island, a couple of days ago, said, no, immigration is wrong. He unpaused it, that they should continue processing for those applications that are already with them. Now it's a ruling by Rhode Island Federal Court. If immigration complies with this ruling, many long delayed cases could start moving again. That's what we are hoping for. But however, I have to be honest with you, this is not the final chapter. You know, the federal government is going to appeal this, or they are going to seek a stay of the decision. So the legal battle is likely to continue. We have not had that stay here, but we know it's coming because that has been the attitude of the Trump government. Now that this is against them, you know they are likely to appeal it. So I'm not celebrating too much early, okay? Or they're likely to ask for the decision to be stayed while they rush to Supreme Court for Supreme Court to invalidate that decision. The affected countries are many countries in Africa. It includes many countries in Africa and, of course, other countries like Afghanistan, Angola, Republic of Benin, Burkina Faso, Nigeria, my country, is included, Burma, Burundi, Chad, Cote d'Ivoire, Cuba, Gabon, Gambia, Haiti, Dominican Republic, Iran, of course, Laos, Libya, Malawi, Mali. You know, if you are from those 39 countries, I'm sure by now you know that your countries included Venezuela, Tonga, Togo, Tanzania, Syria, Sudan, all the Sudans, they include Zimbabwe, Zambia. That judge is saying they can't post, they shouldn't be posting your application, they should be processing it if it is pending. So why does this matter? This is very much welcome news for thousands of immigrants whose cases have been sitting in limbo because they were born in one of these affected 39 countries. For many applicants, the delay meant months or even years without work permit. We have been seeing people have been forced to stop working because their work permit was not renewed. They've applied, but the thing is just standing there. That those who are entitled to a green card are not getting it. Those who are supposed to get their citizenship processed are not being processed. And I think this ruling also sends a very important message. And that is, immigration cannot create sweeping immigration policies that go beyond the authority Congress has given it. At least we still have some judges who are fighting for us. So federal courts remain an important check on executive agencies when they have exceeded their legal powers. That's what this ruling shows for me. Still, we are waiting for our immigration to announce that they will implement the decision, or maybe they're going to appeal. And until they do that, many applicants may not see immediate movement on their cases. So let's not be too jubilant here, but it's a good step in the right direction. So what's my strategic recommendation here? If you are from one of the affected countries and your immigration case has been delayed because of these policies, this is the time to reconnect with your attorney and review your file. We've actually been getting very successful in these last couple of weeks in getting some of those cases to move, where your EAD has been pending for 6 months, 9 months, and it has not been decided. You want to talk to a lawyer. We've been having some great success doing that. Maybe your green card application or citizenship has been hanging for months. There are now some new ways that we're using to approach this now. Now they have the ombudsman, they have the Congress, they have all these avenues we can use to help you get movement on your case. But don't assume your case will automatically start moving. Monitor your immigration account, your USCIS account, respond promptly to requests for evidence, and be prepared. Be prepared if the agency resumes adjudications. Most importantly, let's not celebrate too early. A favorable court decision is encouraging. I love it. But immigration litigation often continues through the appeal process. They don't agree like that. So the smartest immigrants stay prepared for both legal victories and legal reversals. We wait. In immigration law, hope is good, but as I always say, preparation is much better. Prepare. Talk to a lawyer that knows. Let them help you look at your situation and be like the Boy Scout. Be prepared. All right, when we come back now, we take your questions and answers. If you have not yet posted your question on the chat, please do so now. We are live on LinkedIn. We are live on Twitter. We are live on Facebook. And I think we are also live on YouTube. Wherever you are watching this from, if you have questions, please post it. And over the next hour or so, I'm going to try my best to answer as many questions as I can when I come back. In the meantime, I have a couple of videos I want you to watch where I've answered some questions there that will actually help you back at home. When I come back, we go to the live Q&A. My name is Ope Banwo, and they call me the Immigration Rottweiler. Not because I bark, not because I make noise, but because I don't let go. When your case gets tough, when the system pushes back, when others start telling you there is nothing we can do, that's when you call me. Because once I lock into your case, I don't stop, I don't quit, and I don't back down until we get results. So go book a consultation on speakwithope.com now, and let's activate the Rottweiler mode on your case before the immigration knocks on your door. But as I began researching more into immigration law in the library, I discovered something even more shocking. There were dozens of legal pathways available to immigrants, not just asylum as I thought. There were visas for extraordinary ability, visas for athletes, visa for performance, employment-based visas, several of them, family petitions, investor visas. Many highly educations around me could have qualified for visas like O visa, EB1 visa, or EB2 visas, visas that could have given them permanent residency. But they didn't even know those options existed. So they lived underground, fueled by rumors of those around them, working out jobs with their degrees, hiding from immigration, living far below their potential. And then I also saw something even more heartbreaking for me. So some immigrants, when they finally gathered the courage to apply for legal relief, but when immigration scheduled them for interviews or court hearings, they ran away. Based on the advice of others, they believed the interview was a trap. What they didn't realize was that running away often destroyed their chances permanently of staying in this country. Yes, I hope you watch that and you listen to that. Delay sometimes might rob you of a permanent adjustment opportunity that you have. Let's get to the Q&A for today. I know many of you have been waiting for your questions to be answered, and I'm going to try my best to answer as many of them as I can. I love to give full answers so that you can learn. I'm not one of those lawyers who will just give you a little and say, yeah, go book an appointment. No, I'm going to answer it to the best of my knowledge, take my time, and hopefully, as I address some of these questions, it will help you and your situation at home, and you won't even need to spend any money contacting a lawyer or booking a consultation. So here goes with my team, Samuel and Grace. Let's keep the questions up. Keep sending them up now. Let's go. All right, let's go. The first question for tonight is from Priya in Detroit. It says, my wife's H4 I-94 expires in 2026, but her H4 approval and EAD are still valid until 2028, how can we update our I-94? Well, prayer. Because the shortened I-94 was issued due to the passport expiration date at the time of entry, this is often not considered a CBP error. It's not an error on their part. If the deferred inspection office has declined to correct it, then your wife may need to file a Form I-539, is what they call it, Form I-539, application to extend or change non-immigrant status. The form is available on the immigration website, the USCIS.gov. You use that to request an extension of H4 status using a renewed passport and current approval documents. Using the dates on the approval documents, you can attach all of that to request an extension. Another possible option could be international travel and re-entry with the renewed passport, the valid visa, of course, if applicable, and your H4 approval notice. Because when you go out and upon re-entry, CBP may issue a new I-94 that is valid through the H4 approval period now, because now you have a passport that is longer than the H4 period in expiration. But I also have to be honest with you, travel should be carefully considered because every admission decision is discretionary now. Don't want to be like, oh, I told you to go out outside the country, and then when you're coming back, you run into problems. I don't know your personal situation. That's why all the advice I give here is simply with a disclaimer. Before you act on it, you need to talk to a competent immigration lawyer so that they can look at your specific situation and then advise you whether the advice I gave is appropriate for your situation or maybe not. But it's important for you not to rely on the EAD, that's the employment document, or the approval notice alone. The I-94, like I said at the beginning of the show, generally governs the number of days you are authorized to stay in the US. Not what your EAD says, not what your approval notice says, not what even your passport says. What is on the I-94 that you get on the website of the CBP these days. And I will advise you to consult an immigration attorney before your July 26 expiration date. Because no matter what, you don't want your expiration date to pass before you start looking for solution. At that point, it's too late. So tell your wife that. Okay, hope that helps you. I hope that comprehensive answer helps you. Let's hear the next question. Grace, let's go. I visited my US girlfriend on ESTA. Okay, that's an electronic system for travel. Okay, I visited my US girlfriend on ESTA twice in the last year, including a 45-day stay. Okay, I did some remote work for my UK employer while here, and now I want to return after 3.5 months. Is entry risky? Visited your US girlfriend on ESTA 2 times last year, and you stayed 45 days in one of them, and now you want to return after 3.5 months. Is entry risky? Well, James, there's always some risk. See, ESTA, this electronic system for travel authorization that you refer to, it allows temporary visits, but approval does not guarantee admission. The fact that you are approved on the ESTA does not guarantee admission for you anymore. CBP, that's the Customs and Border Protection. Those officers at the point of entry, they are the ones that will evaluate each entry and may question travelers who make frequent or maybe lengthy visits, especially when they have a romantic partner in the US like you, and they may question you about all of that and your future immigration plans. You want to stay here, they'll be asking you stuff like, maybe your plan is to stay here with your love or whatever. Remote work is also a concern. because unauthorized employment can create immigration issues. Because you are doing the work, even though the work is being felt by remote, the work is being done right here in the US. So if CBP concludes that you work in a manner that is inconsistent with ESTA rules, it could affect your admission decision in future. So you need to look at this thing very thoroughly. Now, a future K1 visa case is generally not ruined in case you are thinking about getting a K1 visa from your fiancé. That may not necessarily be ruined because you visited your partner. However, I will say this to everybody now. Always be truthful with CBP. Those guys are not playing. Be truthful with them and on your future immigration applications. Misrepresentation can create far more serious problems than the travel history itself. I hope you got that. I would advise you to actually speak to an immigration lawyer in your area or book one by remote to talk about this, especially your remote work, how that may end up affecting you in America and how to respond properly when you are challenged or when you are asked about this at the point of entry. And also how to present yourself properly about this, your fiancé that you have here. Okay, because they start to look at you. If you have a fiancé, the chance might be that when you come in, you are not planning to leave, and then you want your fiancé to file for you while you are here, meaning that you already intended to stay here permanently. That's what they'll be hinting at you. That's what they'll be asking you some of those questions, and you have to be careful how you answer those. There are technical things, and you should talk to a lawyer about that. All right, Grace, let's go. Next question. So this is interesting. Is a passport number alone enough for someone to access my immigration records or flag me with immigration authorities? Michael from Seattle. Frankly, I would say generally no. A passport number by itself is usually not enough for someone to access your immigration records or to successfully flag you with immigration authorities. Immigration, believe it or not, even now, and other agencies, they have privacy protections and identity verification requirements before they will release case-specific information. Multiple identifiers and proof of identity are typically required before they will give information on your case. They're not going to give information just because somebody quoted your passport number. However, if someone submits a report or a complaint about you to an immigration agency with your passport number, the government may choose to review the information that is provided. They may not give information about you to that person if all they had was a passport number, but if they filed a complaint with your name and passport number, then immigration may choose to review that information. Now, whether any action is taken depends on the credibility of the information and the independent verification by that agency, not simply because they have your passport number. They're going to do a little bit more before they act on it. So it depends on what your passport number is being used for. So if you are concerned that someone has obtained your passport information, you need to monitor your immigration account, keep your documents secure, and consider possibly requesting copies of your records through something called FOIA. That's Freedom of Information Act. If you are suspecting that they may be misusing your passport because you said access, so I don't really know what you have in mind. But if you suspect that they may try to use your passport for something illegal or something that is bad, you want to maybe do a FOIA to make sure they've not done anything on your records. Okay, you want to monitor your immigration accounts. You want to keep your documents secure. But truthfully, in most cases, a passport number alone does not give a private person access to your immigration file or your case history or confidential records. Most of these agencies will ask a lot more than just passport number before they start blabbing your information. But they may investigate you if somebody files a complaint and gives them your passport number. I've seen people stopped at the point of entry because somebody complained about them to immigration and quoted their name and passport information, which they were able to put on the system. And when you come in, then Kasala burst from there, as they say in my country, right? So it depends on what they are planning to use your passport numbers for. If it is to get information, they're not likely to get any. But if it is to put you in trouble by getting you flagged by immigration, most certainly. Because all for them, depending on how serious that allegation is, they can flag your passport on the system so that when you come in, they take you for a secondary inspection. But they still have to get some independent verification before they actually use it against you. So be careful out there, James or Michael. All right, let's see. Next question. Another H1B question. This H1B people. All right. My H1B transfer was filed in September 2025 and is still pending. I had a valid H1B and an I-94 when it was filed. Very good. Now, does the 240-day rule apply, or does AC21 portability allow me to keep working? Ray, this is a very good question, especially for those in the employment-based regime here. In this situation, I think AC21, that is the American Competitiveness in the 21st Century Act. That's, I like to, all this abbreviation, I don't like abbreviation much because lay people who are listening, they get confused. AC21 simply means American Competitiveness in the 21st Century Act. It's a law that allows people to port their H1B from one employer to the other. So I think in this situation, AC21 generally governs work authorization, not the 240-day rule. In this your situation that you described. In other words, if your new employer filed a non-frivolous H1B change of employer petition for you while you are still in valid H1B status and you had an unexpired I-94 at the time, you are typically authorized to work for the new employer while the petition is pending, even if it's more than 240 days. So the 240 days is not what governs in that situation, but while that petition is pending. I hope I'm being clear here. It's a little bit technical stuff, most of these employment-based stuff. The 240-day rule is primarily associated with a timely filed extension of stay for the same employer. In other words, if you're the same employer you're working for files an extension for you, then the 240-day rule applies. But H1B portability, the AC21, is a separate provision that allows employment with the new employer upon filing. And it will generally continue until immigration makes a decision on your petition. Even if it took them more than 240 days to make a decision, you are going to be in valid working status. But that said, long pending cases can create practical concerns. And many employers choose premium processing to obtain a final decision more quickly. And I encourage that. I tell my clients that it's not a question of, oh, I don't want to pay money to immigration. That money that you pay for premium processing saves you a lot of headache, and it may save your American dream because you don't want your case to be pending for long. In your case, given the complexity of your case and the extended delay, you should continue working closely with your employer's immigration attorney. Most companies who hire H1B now, they have an immigration attorney that represents the company. You want to work closely with them so that you can take advice from them on what they think is best for you. But the 240-day rule is very different from the AC21. I hope you understand that. The 240-day rule governs when an employer who files an extension for you, the same employer. But if it's a new employer who is filing for you to change your employer from one to the other, then AC21 will allow you to work until that petition is decided, regardless of how long it took for immigration to decide that. I hope that makes sense, and I'm sure it will make sense to you if you're in the H1 category. Is this employment-based things could be a little bit technical, and that is why I tell people it's not something you just try to calculate yourself. Talk to a lawyer. If you're in H1B, more than likely your employer has an immigration lawyer on payroll or retainer. Talk to them. But if you don't trust them or you don't think they have your interests at heart, then certainly you want to talk to an independent immigration lawyer, if only to confirm what they are telling you. At least that lawyer will be speaking to your own interest versus the lawyer that is speaking to the interest of your employer. Because I've seen many times where the interest of the H1B employer does not align with the interest of the H1B person. So you need your own lawyer to be able to tell you what's up, what your rights are, and what you can do as far as that other employer is concerned. All right, let me see some of the comments on there. Where can one send question? Moses, you just tap it on the chat wherever you are watching this. I think you are on YouTube from what I can see of the icon there. Just tap it in the thread where you are watching this. Most times it will show up in the studio for me, and then I'll be able to pick it up from there. Even if it doesn't show up, maybe because you have not authorized StreamYard to publish your questions, my staff, they are all on those threads. I have 2 permanent staff that work on this show with me, and those who are also working on other stuff for the company, they are all on our live threads. They will see it, and they can copy it, and they will send it to me in the studio. I'm using a StreamYard studio right now to do this broadcast. But thank you, Moses, for asking that question. That question, we've got a lot of people tell me they don't know how to send me questions. That is one of the ways. We are actually working on a phone number where you can actually call into the studio, but that has not yet been implemented. They are telling me I need this, I need that to get it done. And me, I'm not into all this long thing. But we're going to work it out very soon because by next week, we are going to weekly. Every Monday or so is where we're going to be doing this. So we have time to set up a more elaborate studio presentation. This one is just a StreamYard that we are using, and it has limited features. Next question. I live in the US on H1B, another H1B on my DS-160. By the way, I hope you H1B people know there's an update that where they actually canceled that $100,000 requirement for new. I don't know if I've given that update today or not. I thought that was also massive for those in that in the H1B team. All right, but let's take this question. I live in the US on H1B. Congratulations. And on my DS-160, that is the application, for those of you who don't know what that is, the online non-immigrant application. Should I list my home country as my principal residence? Anil, if you are living and working in the US long term on H1B, the US is generally considered your principal place of residence. So for that DS-I-160, on that question, if applying in your own country for visa stamping, and you currently live and work in the US, you will typically answer no. Because your principal residence is the US now, not your home country. I hope you get it, because if you are working long term as an H1B person, then the US is your principal place of residence because you are here. More than 9 months of the year, you're working here. For 2-3 years, then you can't say your principal place of residence is your home country. So the DS-I-160 is assessing where you actually live, not your nationality. I hope you understand that. Always answer consistent with your employment location. That's actually where the place that will determine your place of residence. Because that's where you are working, where you are, at least Monday to Friday. Even if you are in Canada and you go to Canada every weekend, you live here Monday to Friday, so your primary place of residence will be the US. Always answer consistently with your tax residence. Where do you file tax on? Remember, if you stay more than 6 months in America, you have to file your tax here. If you stay less than 6 months, then you file your tax in your country of residence. So that's what determines where your place of residence is, your physical residence history. So always answer consistently with that. Your employment location, your tax residence, your physical residence. Those are the things that determine your primary place of residence. And these things can turn out to be very important, is what I'm talking about when I say don't try to do anything with immigration without talking to a lawyer. Because the instinctive thing for most people is to put their own country as their primary place of residence. Maybe that's where they own a house, maybe that's where they grew up, but that would be wrong if you put that. If you're an H-1B and you have been here for 2-3 years, where you work here, where you work, where you file taxes, is your primary place of residence. So thank you so much for that question. Now let's go to the next one. Samuel Grace, let's go. Next question here says, am I allowed to stay in the US while my J1 persecution waiver is in the RFE, request for evidence? And my current J1 status is about to expire in a few days. Am I allowed to stay in the US while my J1 persecution waiver, okay, you mean waiver based on persecution, or what are you talking about? It's in the RFE. Now that was the queried it, okay, and your current J1 visa is about to expire in a few days. That's an interesting question. And I'm going to say, off the cuff, Dr. Samuel, that it depends on your specific situation. A pending J1 persecution waiver, that application by itself does not automatically extend your J1 status or provide authorization to remain in the US after your authorized stay expires. You need to understand that the fact that you have filed a J1 persecution waiver does not automatically extend your J1 status or provide you authorization to remain in the US if your authorized stay expires, if your I-94 expires. If your J1 status is ending soon, I think you should carefully review your forms. I think the I-94 and other pending immigration filings to determine whether you have another basis to remain in the US. And the fact that the immigration issued you a request for evidence and is waiting for your response does not necessarily protect you from accruing unlawful presence if your underlying status expires. Now, of course, you could argue, and your lawyer will argue it successfully, that while that thing is pending, you are not really accruing unlawful status. But if they deny it 6 months later, your unlawful status will date back to the first time that your I-94 expires. This is important. You don't start accruing unlawful status on the day they deny. Your unlawful status will begin on the date your I-94 expired, even if it is 1 year ago. That means you have acquired 1 year unlawful status. But while it is pending, you are considered to still be in status. And you hope that they approve it, in which case, good for you. But if they deny it, then now you have accrued unlawful presence since the time the original I-94 expires. So if it is more than 6 months from that, now you have acquired unlawful presence that will ban you for 3 years. If it is more than 1 year that it was pending, now you have acquired unlawful status that will ban you for 10 years. So this is something you have to review very carefully with your lawyer to see if you want to port to a different category while before your I-94 expires. Now, because persecution waivers, they involve complex immigration issues, and you already know that maybe, and potential serious consequences, I'm going to advise you, it is important for you to consult an experienced immigration attorney immediately before your J1 expires. Then the attorney can evaluate whether you have a lawful basis to remain in the US while the waiver is pending, or whether additional filings may be necessary. I don't know. But given the very short timeline that you have indicated, I'm going to strongly encourage you, seek legal advice as soon as possible. You don't want to wait until that J1 expires. It don't matter what you have pending. That could have mega consequences for you. Right? I hope you get it. I hope you take it serious. I hope you don't try to say, I'm going to save money, because a lot of people in J1 and H1B, they're very smart people, medical doctors, researchers, and all these top level people. A lot of them, they do a little research and they just want to do their case themselves. Many of them are finding out the hard way now that it's not the same game anymore. Okay? There are some things, if you're not a lawyer, you just can't put together. Simple question. You can turn your life into a nightmare here. It doesn't cost you much to go book a consultation. Listen to what the lawyer has, have all your questions for him ready. So after you have listened to him, then you can decide if you want to do stuff by yourself or you want to hire the lawyer. At least you spend only $100 or $200 for that consultation. It's money well spent versus just assuming that you know more than the lawyers, do what you have to do, and then at the end of the day, your case is over messed up by the time you're not calling a lawyer. I've been in that situation where somebody with a J1 that I expired is now coming to me, and I'm like, there's nothing I can do at this point. You're done. You're going home. No matter, even if you marry an American citizen now, you're going to have a problem because you have a J1 with no waiver of the foreign state. You're done. But if they had spoken to a lawyer before then, maybe there could have been some moves that the lawyer could have recommended that will help you out of that jam. Right? A word is enough for the wise. I hope you listen, Samuel, Dr. Samuel, and do something. All right, let's pull up the next question, guys. Let's go. Let's go. My I-94 was denied because my attorney failed to present key marriage evidence. Can I reopen my case based on ineffective assistance of counsel? I don't even know what that is. And new evidence. I love it when people do plenty research. It says my I-751 was denied because my attorney failed to present key marriage evidence. Can I reopen my case based on ineffective assistance of counsel and new evidence? Maybe it's obvious you've done some research, so I'm going to say probably. You probably can do that because immigration law allows certain cases to be reopened based on ineffective assistance of counsel. And in some cases, newly discovered or previously unavailable evidence can also be a basis for you to reopen your case. However, you have to understand this. These motions face very strict procedural and timing requirements because it's a loophole that a lot of people use. It's another reason why it's also important for you to get a lawyer for your case so that if a mistake is made, you're going to be able to get another bite at the apple to reopen your case if your lawyer is the one that screwed up or if you have a new evidence available. But these motions, they have very strict procedural and timing requirements that you have to follow. For instance, to pursue an ineffective assistance of counsel claim, you generally must comply with the requirements established in one case that they call it matter of lozada. I'm sure you probably already heard of it if you know what ineffective assistance of counsel is, because the two go together. There's a case called matter of lozada, which often include notifying former counsel of the allegations and filing or explaining the status of a disciplinary complaint. In other words, for you to file ineffective assistance of counsel, you have to let the lawyer that you are saying is ineffective, you have to let him know, and then you have to file a complaint with the bar and show proof of it. So essentially, you are going to be going after your former lawyer, basically trying to destroy him in order to reopen your case. So it's not as easy as you think it is. But you can do that if the lawyer did screw up. Hey, it's all right to do what you got to do. Okay, but understand that for that to stand, you have to be able to follow the guidelines that was stated in the case called Matter of Lozada. You can research more on that or talk to another lawyer about this to get some clarity. It's not just as simple as saying I'm going to say my lawyer was ineffective, so they should reopen my case. No. And they're also subject to some procedural requirements. Now, on the other point that you raised, new evidence. Now, if you have a new evidence that just came up, it may support reopening your case if it is material and that information or new evidence was not reasonably or could not have been reasonably presented earlier. In other words, that new evidence did not exist at the time or could not have reasonably been presented. Maybe you don't have access to it. Maybe the thing is in your home country and you have applied and the thing didn't come before your case. If you're able to show that it is material to your case and that you could not reasonably have presented it earlier, then it may allow you to reopen your case. Medical documentation explaining why you are unable to address prior deficiencies in your case may also be relevant. And a lot of lawyers are using that. Now, if your case has already gone through removal proceedings, appeals, and Board of Immigration Appeals, then the procedural history becomes very complex. So a thorough review of the complete record is essential to determine whether reopening options remain open to you. So I'm still going to have to say you have to talk to a lawyer on this, because you see, if your case has gone far, it's not just as simple as giving you an advice on my show that without doing a thorough review of the complete record. I don't want to mislead you. I don't want to give you half advice. So a thorough review of your complete record is essential to determine whether any reopening motions remain open to you, especially if your case has gone through Board of Immigration Appeals or has gone through federal court review. That's all complex. And it's not something we can determine with just a simple question to the show. So I would say you should promptly consult an experienced defense attorney, immigration attorney, for them to do what is called a de novo review of your file. In other words, to review your file from all over again, and to also review all prior filings before you pursue further action. Go do that right away if I were you. That's what I'm going to do. That's what I'm going to do. I'll get a new lawyer to look at my case de novo from the beginning all over before taking any further action, especially if your case has already gone far from what your extended note to me said. I will just have a short one that can feed the screen. Your note was very long and it's like your case has gone all the way to Court of Appeal and all of that stuff. That's a complex thing, right? Okay, I hope that gives you some little bit of clarity on what to do as far as this ineffective assistance of counsel is concerned. Oh yeah, Samuel, let's get to the next one. Okay. How can my US citizen son file a green card or US citizenship for my daughter in India? This is from Ravi. I always hear this and sometimes I laugh. Ravi, your son cannot directly apply for US citizenship for his sister. US citizenship generally requires an independent eligibility path, such as being born in the US or being born through US citizen parents. It's called derivation through parents or naturalization. That's how you get citizenship. It's not something your son can just file for his sister. But I want to assume you are talking about green card, because you said green card or citizenship. If it is green card you are talking about, then it depends on your son's age. Listen carefully. Again, these things are calculated. If your son is a US citizen and your son is at least 21 years old, he may be able to file a Form I-120, Form I-130. It's called Petition for Alien Relative. It's available on USCIS.org, their website. So if your son is a US citizen and at least 21 years old, he may file an I-130 petition for a sister. But the sister will be under the F4 category, which is for siblings, the F4 category. If it's under 21, he cannot sponsor a sibling. You have to be over 21 before you can sponsor anybody, whether sibling or father or whatever. So if your son is only a green card holder, if he's not a citizen yet, he cannot sponsor a sibling. Only citizens can sponsor siblings. Now, you need to keep in mind that sibling petitions for people born in India, because you mentioned that you're from India, take a very, very long time, what they call long waiting times, because of visa backlogs. I think India and one other country take a very long time. The process can take many years before a visa becomes available. That is, if a US citizen brother is filing for their sister. Now, if your daughter is under 21 and there are other family-based options available, those may be faster. So a detailed review of your family's immigration history will help you identify the best pathway. Talk to a professional about that. But if it is brother to sister, number one, unless your son is a US citizen, he cannot file for a sister. And if he's a US citizen and he files for the sister, there's a very long waiting period. So if your daughter is still under 21, there may be other family options available for her, especially from India, that may be faster. You need to get somebody to do, a lawyer to do a detailed review of your family's immigration history to see if they can identify a faster pathway for her. It's not easy when you see the number of years you have to wait. If you're brother or sister of a US citizen from India, you probably will pass out. But there are always other ways. Just get somebody to do a thorough review for you. Let's pull up the next question, please. Hope that helps you, Ravi. Now let's look at the next question. Aha, these are the type of things I was talking about in my opening memo. Vikram says, I accidentally answered no on my global entry application when asked if I had ever violated immigration laws. How can I correct it without affecting my green card? Vikram, the best course of action I would advise is for you to correct this mistake, is for you to do it as soon as possible and be completely transparent. An honest mistake on your global entry application is generally less concerning than failing to disclose it once you realize the error. Now, if the application has already been submitted and you cannot edit it anymore, then you can explain the mistake during your global entry interview or contact this thing they call TTP, the Trusted Traveler Program Support System. You can contact them to inquire about how to update your record. You bring documentation showing that your prior status was disclosed during your green card process and that USCIS approved your whatever it is, bring the documentation. For me, I will reassure you a little bit that a corrected global entry issue alone is unlikely to jeopardize whatever it is that has been approved for you. But intentional misrepresentation could create problems. or your failure to fix it immediately. Like I just mentioned to you, you want to contact the TTP and all the support system to try to fix it as soon as possible. Be proactive, be truthful, and consistent in all your communications with Custom Border Patrol. There is nothing that can ruin you faster than for you to give CBP inconsistent answers. They can ban you for a very long time. Problems can arise. Be consistent, be truthful. They will generally excuse an honest mistake that you admit immediately that they are not the ones bringing it to your attention. By the time, if you wait for them to bring it to your attention, at that point, you are not going to get benefit of the doubt. So please go correct it, as you said, without affecting your green card, because once you contact those agencies that can help you, the TTP, I think you go to their website. I don't know, I can't remember the website offered. I don't do enough of that to have it, but I know they are called the Trusted Traveler Programs. They have a support system. If you search that, or the Global Entry Office, you type that, you generally get some information online that you can then go use to fix this problem. Okay, let's take a few more and then we'll call it a day. We are already at the, we're almost at the 2-hour mark. There we go. I filed an adjustment case. I filed an EB2 adjustment of status case in February. And I'm still waiting for my EAD, that's the employment authorization card, and my advanced parole, which is the I-131. Is this delay normal? And how long do these applications usually take? Yes, David, this type of delay can be normal if you're looking at, you're talking 4 months. Processing times for I-765, which is the employment document, and the advanced parole document, the I-131, they vary significantly based on USCIS workload, case volume, and the background checks they have to do. For employment of adjustment applicants, for employment-based adjustment of status applicants, which you are, it is not unusual for EAD and advanced parole processing to take several months. Some applicants receive a combined approval relatively quickly, while others wait longer, depending on the service center that is handling their case. In fact, I have several people that I'm helping now to try to get their case fast forward in immigration now. There are ways that you do it that you even get faster response now. They have what they call the ombudsman. In case you have never had it before, there's now an immigration ombudsman. If your case has been pending for 4-6 months and you have made an inquiry on the USCIS website and you're not getting traction, you can actually apply to the immigration ombudsman. It's like an office that is between immigration and the intending immigrants, and they're very effective. I've gotten some amazing results from them in a matter of days recently. Even I was surprised. Immediately they get your petition, they get on it immediately. They will respond to you by email. If they need more documentation, they will ask you by email, and they call immigration immediately. They handle it. I've gotten them, for instance, to be able to help me get a work permit approved in literally under 10 days. I was stunned, and that has been pending. One of them has been pending for 6 months. Another one has been pending for like almost 24 months. You are complaining. This person had their work permit that has been pending for about 18 months. And when it came to us to help them investigate and follow up, we simply use what I call a 3-pronged approach, which I also encourage you. You can do it yourself, or you can go get a lawyer that will do it for you. You follow by doing what is called case inquiry on 3 levels. First, there's a way you approach the USCIS formally with your lawyer to find out about the status of your case. Then there is the Immigration Ombudsman. It's a great office. A lot of people are not aware of them, but from what I have seen in the last 2 weeks, they're very amazing. They've gotten 3 cases resolved for me, just like that, within a matter of days. Of course, those cases have been pending, like I said, 6, 7 months, 14 months, 16 months. and the clients have made inquiries before. They just ask for some information. There's a way you package the thing for them. There's some documents they require. Your lawyer can help you with that, or you can go to their website and go study all the stuff they want and get it for them. Because immigration, they are sometimes overwhelmed these days. Sometimes they transfer cases for workload balancing or further review. They take it from one office to the other. Also, the field officer that was assigned to a case may live in a different place, your different location. So the best way to determine whether your case is outside normal processing times is to check the USCIS processing time tool. They have a tool on their site. The USCIS at uscis.gov, they have a processing time tool that will tell you around what time a particular type of application is taking now. And then you can also check your online case status on the immigration website. It is free. It takes a few minutes. You go in there, you put your information there. It will tell you what the status is. It will even give you a receipt, and you need that. Because if you are going to escalate, the ombudsman will always ask you, have you contacted immigration? What have they said? And then there is the third option. You can also go through what is called congressman inquiry. I mean, you probably have heard about congressman, but a lot of people misuse the congressman option. Okay, congressman will not make immigration give you a status you don't deserve. Like somebody was telling me that they filed a case, but they are not sure they have all the requirements. That can the congressman cannot help you on that one. Congressman is not going to tell immigration to waive a legal requirement. That's not their job. But if your case has been pending for a long time, if you believe your case was strongly decided and you have proof of it, if a document was supposed to have been sent to you, but you never got it, that is the place where the congressman is very effective. Because sometimes with just one letter from them, or just one phone call from the officers or assistants of that of that congressman, immigration will take action. I've seen all of that recently, and it's amazing how effective they can be, especially if you are asking your congressman to intervene in a matter that is directly allowed for them to intervene, which is issue of inordinate delay. If your case has been pending for a long time, if your documentation, if you got a letter saying that you have been approved for your work permit, but work permit did not come, stuff like that, they're very effective. So you combine all three. You reach out to immigration yourself through the special way that lawyers go. Then you also do the ombudsman intervention petition, and then your congressman. You do all those three within the same week. Typically, you get some result within 2 weeks. I hope that really helps you, because I've seen several of my clients get amazing results with that, what I call a 3-level attack, if your case has been pending for a while. Because I'm reiterating this a lot and sharing this strategy with you, because it has worked very well for me in the last couple of weeks. In a matter of days, I'm getting results. And also because I know a lot of people are dealing with delays in their cases now. So it is becoming a very, very strong procedure to follow. That's why I explained it. 3 levels: USCIS case inquiry, immigration ombudsman petition, and then also congressman intervention request. They're a little bit technical, the kind of things you have to put together and all of that. But if you use those 3 together, I can tell you within a month you're going to get some updates. Immigration will get back to you. But I prefer you get an immigration lawyer to help you. Pay them whatever their money is. Immigration is expensive now. Pay them. They can do a better job for you compiling this. Of course, we are specialists in this now. You can contact us if you want. speakwithope.com. But it's something I believe almost any immigration lawyer should be able to handle with a little research. Tell them Dr. Ope said they should do inquiry on your case on 3 levels. USCIS request, a formal request through a lawyer, immigration ombudsman petition, and then also request for intervention by your congressman. Is their job. Every congressman has somebody there in their office that their job is to help their constituents, especially with their immigration status. They have it. It's a question of following the procedure to get them to intervene. Sometimes it includes calling their office. They all have their phone numbers available online, then asking for instructions on how to get them to move on your case. Sometimes you send them an email. They have the information. You send them email. They get back to you. They send you a consent form to sign. They send you whatever. But they're pretty effective. Do that with your lawyer, and you have a better result. But you can also do it yourself. I don't want to give you the impression that everything you must go use a lawyer. If you are pretty smart and you're educated and you can do some research yourself, following those 3 strategies will get your case to move faster. You can thank me later after you use it. All right, I think we are coming to the end for today. When we come back, I will see if we can answer more questions or bring the matter of today to a close. But before we do that, I want you to watch a couple of these videos. Hopefully, the questions are answered in them will be able to help you. Enjoy.
If you are trying to live and work in the US based on your skills, education, or professional experience, let me be direct. Your success or failure often comes down to one thing: how well your case is structured from the very beginning. Because immigration is not impressed by your potential, they respond to properly positioned evidence only. I have seen highly qualified professionals, engineers, executives, doctors, founders get denied, not because they were not good enough, but because they chose the wrong visa category. The documentation was weak, or their petition lacked a clear legal strategy. And once a case is filed the wrong way, fixing it later becomes much, much harder. Now, here's the hard part most people don't understand. There isn't just one path to immigration in the US. Depending on your background, you may qualify for EB1 for extraordinary ability people, EB2 national impact people, EB3 skilled professionals, H1B specialty occupations, O1 exceptional talent, and many more like that. But choosing the right path and presenting it clearly and correctly, that's what you need. At Banwo Law, we don't just file applications. We build strategic immigration cases. We evaluate your profile, identify the strongest pathways, and structure your petition based on how immigration actually reviews cases. From documentation to legal positioning to long-term approval strategy, everything is done with one goal in mind: approval. So if you're a professional with specialized skills, a business executive or manager, a techie or healthcare professional, an entrepreneur or founder, or someone with some exceptional ability, then this is exactly where you need to be. If you're serious about building your future in the US, don't leave your case to guesswork, online advice, or trial and error. Call us now at 888-215-5054 or schedule a consultation with me on speakwithope.com to get clear, strategic path forward. Because when it comes to employment-based immigration, the right strategy doesn't just improve your chances, it defines them and gets it ready for approval. My name is Dr. Ope Banwo, and I'm the founder of Banwo Law. We represent professionals nationwide across the United States. Someone posted this: I was arrested, but my case was dismissed. Will immigration still hold it against me? My short answer: yes, it can still matter. But first, my name is Ope Banwo, and for over 29 years, I've been helping immigrants achieve their American dreams without the nightmares. Many people believe that once a criminal case is dismissed, it disappears completely. And no, but immigration law does not always see it that way. Immigration looks at the full history, not just the final outcome in criminal court. Let me give you a few real-life examples. Say someone is arrested, and even though the case is dismissed, the record of the arrest still exists and may come up during background checks and cause problems in your immigration case. Another scenario, someone makes statements or signs documents during the arrest process that would later create issues in immigration law, even if the case never went forward. Another scenario, somebody has multiple arrests, all of them dismissed, but immigration can still look at the pattern and raise questions about credibility or admissibility. So the key point is this: dismiss does not always mean invisible, and immigration officers may still review what happened, not just how it ended, and use it against you. That is why it is important to understand your criminal history, even dismissed cases. You need to understand how they interact with your present immigration case. If you've ever been arrested and you are now trying to fix your status, do not assume that it will not matter just because you are not convicted. Go to speakwithope.com now and book a strategy consultation session. Speak to me today before your immigration dream turns into a nightmare. It matters. She married a U.S. citizen and still got denied a green card. Yes, marriage, legit marriage, but she still got denied a green card. My name is Ope Banwo, and for over 29 years, I have been helping immigrants achieve their American dreams without the nightmares. So she came to me crying. They had already filed everything themselves. No lawyer, no strategy, just forms and hope and belief in their love. What they didn't understand is this: marriage is not the strategy to get green card. Documentation is, timing is, legal positioning is. So they got denied, and she was placed in removal proceedings. Now, instead of getting a green card, she was literally fighting for her life to stay in the country. Before we finally stepped in when they called us, we rebuilt the case properly, reorganized the evidence, prepared her for interview as if we are doing a legal case, not a love story. Now she's back on track, thank God. Now, listen to me carefully. Most marriage cases with immigration don't fail because the marriage is fake. They fail because the case was handled casually with a lot of assumptions. If you are filing through marriage, already filed, and you are not sure you have done it right, don't make the irreversible mistake that most people make. Go to speakwithope.com right now and book a strategy consultation with me. And let's help you handle your case like a professional legal matter, not guesswork, before your American dream turns into a nightmare. Let's talk.
Alrighty. Hope some of those pre-prepared answers help you as you listen. I guess we've come to the end of the broadcast for today. I want to appreciate every one of you for coming to the show tonight. And of course, if you would like to talk to me, if you would like to speak to me about your case anywhere in the world, you go to speakwithope.com. You can book a time that is convenient for you, either to come into our offices right here in our location in Dallas, or you want to speak by via Zoom. We do a lot of consultations on Zoom these days. We'll be more than happy to discuss your case with you. Our consultation is only $100. You can afford that. It is better to spend that money to know where you stand before you start running up and down or doing stuff for yourself. So I want to thank you for being with us tonight. Mr. Samuel, thank you so much for standing tall with us on the show. And Madam Grace, as always, thank you so much for being a reliable part of the team and for doing the great work. And I think finally we came to the end of our 30-day marathon, even though we missed a few days in the process. I want to appreciate many of you that did hang out with us as we officially kick off our Arlington, Dallas office this past month. Hopefully, we continue to provide you amazing service over the next few months and years to come. Our show will go to once a week, I believe on Monday, at the same time, and then we'll communicate all of that, where we come in once a week for 2-3 hours to answer your questions, to share the updates of the week. And of course, every once in a while, when there's an important update, I probably will do what I call a flash live event where we can come on and talk for a few minutes to share the update of the day with you. Remember, always be proactive about your status. Be proactive. The America of today does not allow complacency. You need a lawyer, and you need it now. Get one in your area, even if you feel that I'm too far from you. We represent clients all over the nation. Immigration is federal, and we go everywhere. We have a case. But if you need somebody locally, get somebody locally. Whatever you do, get a lawyer, because it's no longer the immigration of your brothers or your sisters or your fathers now anymore. This is a whole new season. Even me, if I have immigration issue, I'm calling a lawyer. All right, because this is no longer something you can do yourself now. So thank you guys, everyone, for coming in on the show tonight. I appreciate you, and I will see you on the next show. Grace, thank you. Samuel, thank you.
Thank you, sir.
All right, good night.
Good night, sir.
Every year, millions of immigrants come to America chasing a dream of opportunity, a dream of a better life, a dream of becoming something more. But what many do not realize is that the journey is filled with confusion, legal traps, and costly mistakes. And that is why this show exists. This is the Immigrant Survivor Show with Dr. Ope Banwo, where we provide information to help immigrants achieve their American immigration dreams without the nightmares. Pay attention as we break it all down for those who have ears to listen.